All right, we're going to get started on day two of the second annual conference on carbon removal law and policy. Good morning, good afternoon, good evening, wherever you are, and thank you for either once again joining us or joining us for the first time. My name is Will Burns, and I am a professor in the Environmental Policy and Culture program at Northwestern University. And on behalf of our program, the Pritzker School of Law at Northwestern and the Institute for Carbon Removal Law and Policy, I'd like to welcome you. As I said yesterday at the outset, our focus this year is on domestic governance in terms of carbon removal. As we all know, there's a substantial international institutional role to be played in terms of the regulation of carbon removal options, including the potential role of the Paris Agreement, as well as a host of regimes that may be implicated where there are transboundary implications for these approaches. But a lot of what is going to be done in terms of implementing these kind of projects and governing and regulating these projects are going to happen at the domestic level. And so we thought it was appropriate to pull down this year to that level. And our first panel today will continue that approach. We'll fudge a little by also looking at the European Union, given its profound role in establishing carbon regulatory frameworks at this point. And so the focus in this panel will be both on the greenhouse gas removal terrain in the United Kingdom, as well as the European Union. And to host this panel today, I'd like to introduce Anna Dubovik, who is the Secretary General for the Negative Emissions Platform. Anna, it's yours.
Yes, thank you, Will. So good morning or, well, good afternoon, everyone. And it's a great pleasure to be here with you moderating this first panel of the second day. For the conference on this very pertinent topic of domestic law, domestic governance. And let me introduce myself shortly. Anna Dubovik, Secretary General, Negative Emissions Platform. The platform is a trade association founded almost 3 years ago, based in Brussels. We are focusing mostly on EU or European and domestic, as in national regulation of technological removal. So DACs, BECS, pyrogenic CCS, biochar enhanced weathering, mineralization, everything that is removal and durable. And our membership spans technology project developers, technology providers, investors, marketplaces, other sectoral trade associations, and we are also open to membership from other non-profits, consultancies, think tanks. So please do not hesitate to contact me if you want to join the platform and work on the EU law. And I also want to take the opportunity to thank Will, first of all, for the invitation to moderate, and most of all for being instrumental in the early days of the platform in helping to establish some very relevant connections with the US business and policy CDR ecosystem. So thank you, Will. So yesterday we were off to a great start with, high-level keynote from Jen, many enriching discussions on the intricacies of the US federal law, the never-ending challenges of MRV for certain methods, the issues of CDR growth, and the issues with certain vulnerable communities. Today, as Will already said, we'll focus more on regulatory policy developments on the old continent, including the UK. And let me introduce our first two panelists. So Mr. Navraj Galay, Senior Lecturer in Climate Law, who's been with the University of Edinburgh since 2003. And his work consists of engaging with practitioners in the climate law, legal professionals, public bodies, society actors. Navraj, he directs the Global Environment and Climate Change Graduate LLM program, which integrates climate research with other disciplines, so business and geosciences. And his current research projects include GGR removal technologies, which will be covered in the presentation, or a very interesting and multidisciplinary project with the UNFCCC Secretariat to develop a framework for assessing GHG across value chains. And Sanja Bogojevic, fellow professor of law at Lady Margaret Hall Faculty of Law at the University of Oxford. So her research is mostly in environmental law and EU law. More broadly, role of markets in environmental law, the green procurement, environmental rights adjudication, climate law. She was awarded a 2016 Niels Kim Prize for her contribution for her book, Emissions Trading, Markets, States and Law. And Sanja is currently involved in several large-scale research projects, including co-leading legal investigation as a part of the UK National Research Hub on GGR removal technologies. So working on this together with Navraj. So we'll kick off with Navraj discussing the landscape of GGR research in the UK, focusing on CO2 project, housed across the universities of Oxford, Edinburgh, Imperial and others. And his presentation is co-joined with Sanja's, who will then outline the role and importance of law and legal scholarship in better understanding, realizing GGR technologies. And this will be followed by a presentation from Dr. Justin Masnante, postdoctoral research fellow in climate change at Edinburgh Law School. Justin has over 15 years of impressive practical experience in the field of climate change, carbon markets, project development experience in China and India, fund management, including for European Investment Bank. And on top of his academic research, he consults with intergovernmental bodies like governance for TSVCM. He's also engaged in a number of research initiatives, the Law School, CO2 Rehab, GGR project, and the projects with UNFCCC Secretariat. So Justin's presentation will discuss the topic of bundling to achieve fungibility in GGR removal units, or to say, what are the minimum parameters for removal units generated by different methods to be considered equivalent. So I'm really looking forward to this talk and the discussion afterwards. And then we'll close with the presentation part with a deep dive from Lukas Strube on legal treatment of biochar, or what we see as a legal absence or uncertainty of framework for biochar, both in the UK and the EU, and how it impacts businesses and investors. So Lukas Strube is a research fellow in environmental law. He's contributing to CO2 Rehab, and he wrote a thesis on EU regulatory treatment of biochar and developed his interest in research of GGR removals. So welcome everyone, and let's kick off with Navraj and Sanja presentation.
Okay, I hope you can all hear and see me. Great. Okay, so I'm Navraj Singhali, and from the University of Edinburgh, and Sanja Bogojevic is my co-presenter this afternoon in Western Europe. And what I'm going to be doing today is really to give an overview of the state of GGR research, and in particular legal research in the UK and the European Union. And we are part of the Core Hub, and this is the team. So you can now see us in two different places simultaneously. The links at the bottom might be helpful for those of you who want to get a little bit more detail on what it is that Core does. So in terms of GGR research in the UK, some of you may be familiar with what was called GGR-A. So that was the first round of government funding in the space, ran from 2017 to 2022. It's about £9 million, very much science and technology focused, as you might expect, and that's now run its course. Around the same time, the UK government requested that the Royal Society undertakes a scoping study into the same space, and I'm sure many of you are familiar with the Royal Society report. which has had a very significant impact in framing the terms of the debate. And one of its more noteworthy features was the introduction of social scientists and economists into that review, something that hadn't previously happened. And that is something that contrasts it with the earlier 2009 Royal Society report on geoengineering, which likewise made a big splash at the time. So where we are now is this, GGRD. There wasn't a GGRB or C. We went straight from A to D for reasons best known to the government. And so this is a 32 million pound investment by the UK government. It's part of something called the Strategic Priorities Fund. It kicked off last year. And essentially it consists of 6 demonstrator projects across a variety of GGR technologies. They're in the parentheses there, I'm sure you're all familiar with them, plus a coordinating hub. And this was put out to the call, I think, was in early 2020. You might be wondering where the engineered removals are. They're dealt with through a completely different stream of research funding, which is actually much more direct to industry than the GGRD program. And it has the goal of assessing sustainable routes for large-scale GGR. So it's very much focused with on the goal of scaling. Scaling is really the central mission of GGRD. In case you're wondering what this little image on the right-hand side is, this is something called a Kumu, which is there's the link to it if you want to check it out yourselves. This was generated by our colleague Mark Workman, and what it does is map the landscape of GGR's investments in the United Kingdom, public and private. And so these rectangular boxes are government departments, which are funding GGR research, and the nodes are different programs and activities. So we are this little rectangle here. So that's our little 32 million pounds part of the pie. So there's a lot going on. So depending on your view, this is either a great example of Schumpeterian capitalism, which is going to sort out all of the answers through trial and error, or it's the Wild West, and it remains to be seen which one it is. So there's a lot going on. Why is there a lot going on? Why isn't this just another scientific, important scientific question which hasn't, into which the money hasn't followed? Why has the money followed? I think there are a couple of explanations, and and the way I frame it in this slide is, why has the 2018 Royal Society report been so much more impactful than the 2009 Royal Society report? Certainly in terms of industry and finance. And I think this can be put down to 3 factors: Cummings, Johnson, and COP26. So to address those in reverse order, COP26 obviously was one of the very first global showpiece events in which the United Kingdom could assert its position or position itself in a post-Brexit world. And there was a lot of discussion along the lines of the United Kingdom becoming a green technology superpower. And actually, it's interesting to note that yesterday, Keir Starmer, who I think sensible people hope is the Prime Minister in waiting, yesterday positioned the United Kingdom as a clean energy superpower. So there's a degree of stickiness to this language, and which also has cross-party support. Second element is Boris Johnson, both personally and professionally, became convinced of the low-carbon transition and saw removals as a central part of this. And he's already been critical of the new Prime Minister's climate policies. And thirdly, and this may not be a point well understood by those outside of the United Kingdom, but this is the role of somebody called Dominic Cummings. Dominic Cummings was like the Rasputin of Brexit. He was a very significant behind-the-scenes operator, and coordinated the campaign. Something of a Svengali. He was called a career psychopath by a previous prime minister. a highly controversial figure, sees himself as a insurgent in government. He claimed that he would hire weirdos and misfits into government to shake everything up and that sort of thing. But one of the things he's out of government now, but one of the things he was very supportive of, and when he was in government, was removals. He's probably the single or one of the central figures for this relatively niche, unknown technology having the degree of support it has. Now, that is a bit of a double-edged sword for researchers, because on the one hand, it's great that we have this profile and this support. GGRD might not exist but for it, but it also adds to a tone of a lack of seriousness. And that lack of seriousness, I think, sort of melds into a broader concern that many people in the climate and environmental community have about GGR being fundamentally unserious. If you're serious about climate change, you do mitigation. Removals can be disparaged in a number of different directions. So this is part of a narrative which is not necessarily particularly helpful, but it's where we are. These questions, incidentally, about the unseriousness or indeed the illegality of GGR were reviewed in a recent case and quite roundly rejected, which was quite helpful. And that's the citation to the case there, Friends of the Earth and Bays. Right. And this is some more of the context. If anybody wants to actually understand the UK government's position on this, the integrated review is the place to start. So, what is CORE, or CO2 removal? So, we won the competition to be the hub for the GGR program. That means we coordinate across the 6 demonstrators. We engage with government, industry, finance, communities, and so on. It's a multidisciplinary team, as you might expect, consisting of geologists and land use modelers and geographers and chemists, and also lawyers. And I think this is the first time that lawyers have been sort of baked into a major multidisciplinary removals research program. So hurrah for us. And what CORE seeks to do is essentially what's on this figure here. So we identified a number of needs that society will need if GGRs are to play the role which the IPCC, for example, says that they need to play. So vision, social robustness, low technology costs, policies and governance, MRV, decision support tools. So this is what we have identified as the core needs. We've split that into a number of work packages, and after 5 years, we say we will deliver all of those marvelous things. So that's the goal. There are, I think it's probably fair to say, not quite parallel research initiatives in the European Union. The most developed one is in Germany. Horizon, just yesterday, Horizon is the European Union's big research funding program. Yesterday closed a call in which some of us are involved in other projects. So there will be more of this stuff happening in the European Union, and we're already cooperating. That is, CORE is already cooperating and coordinating very closely with those teams that already exist. This is some of our research. We started last year, about 12 months ago. We've been quite busy in the space. Luca, top left here, will be saying something about this paper, this excellent paper, which was just published in the Journal of Environmental Law. Justin will be talking about regulating removals and removal units, which was published earlier this year in Carbon and Climate Law Review. NEGEM is one of those EU research projects, which is already well underway, and we had a workshop with them earlier in the year about the integration or non-integration of emissions trading schemes and removals markets. That report you can find there. And I'll be saying something about this question of liability and removals in a moment. So, in terms of what core law is actually doing, there are within the project, there's a variety of cross-disciplinary work streams on life cycle analysis and MRV, equality, diversity, and inclusion, the evaluation framework, modeling, And also there is a regulation and governance working group. And this is a group in which we pulled together representatives from each demonstrator, so the scientists who are working on each particular technology, and they have regular meetings with us, the lawyers, in which there's a descriptive element to the work in which you try to map the applicable law, but also tap that soft knowledge which they have, the scientists, having in some cases decadal experience of working with environmental regulators and local authorities and community groups and landowners and so on and so forth. So there's a great deal of detailed and practical knowledge which is held within the program that we are seeking to extract. Now, I think at that point, I will hand over to Sanya.
Great, thank you so much. So just as Navraj has pointed out, we've been involved in this project for just a bit over a year. And in this first year, much of our work has been to map the regulatory field or the legal field. So there isn't much legal scholarship on GGRs more generally. So what we've done in this initial stage, and very much this is the work spearheaded by Justin and Luca, is to map the different legal frameworks that are relevant for the different technologies. These tables are much bigger and longer and more complicated than what's on the slide, but this is just to give you an example or a very brief overview of the type of work that has been carried out as part of this mapping exercise. So you've seen that we've looked at the different parts of environmental law, so looked at planning, air, land, water, resources, biodiversity. You'll see here that we have the EELS regulation from 2009, which may be relevant for the regulation of BECS. Also looked at waste, health and safety, MRVs. So here we've really tried to map which different regulatory regimes are relevant. But we've pushed that work further. So not just mapping or listing the different regulatory frameworks, but we've also tried to also appreciate the role of law here. And this is the next slide. So Navraj, I'm sorry, but I think you have the control of the slides. So if we move to an example of biochar, and this is something that Luca will come back to in his presentation to talk in more detail, we see here how law has both an enabling impact and a controlling factor. So again, this table is much longer, but if we just take one example here of how we categorize biochar. So we see here under the Environmental Protection Act from 1990, section 33, subsection 4, subsection B, we see here that the Secretary of State can prescribe any means of waste treatment which are innocuous enough to be excluded. They can do that. And then there is the qualification of how you can exclude biochar from being labeled as waste. So this would be, and this is how we see as law being potentially an enabling actor in the use and promotion of GGR technologies. But there is also obviously the controlling factor. So if it's prescribed, or if the waste regulation applies, which it does in this case, then you will need a permit. And then, which makes it also a bit more complicated, that you have both the biochar production element, but you also have the applications and different, possibly, applications of the regulations. And here, the work that has been done, and again, Luca will talk about this in more detail, was thought about the different problems that may emerge here. So for example, we see here in the final table of hindrance or legal complexities, where we have to think about, well, end of waste status that is based on self-assessment and the risks that this creates and the lack of a standardized approach. And so we see here how law is not just about compliance, but also how law can help shape and promote these technologies, something that I'll come back to towards the end of this presentation. But now I'll give it back to Navraj just to give further an example of the legal aspects that we've investigated.
Okay, thanks, Anya. So, liability obviously is central to any discussion of how GGRs will work in practice. It's a question which investors very quickly home in on, and one of the central concerns is around reversal or re-emission or leakage, however you want to term it, whether as a function of inadequate due diligence or of catastrophic events. We know that there's a risk of reversal. The question is, how does one respond? How does one account for that in terms of liability? This came up in a recent UK government report, which essentially, very brief, and this is dealt with in the working paper actually that I alluded to, I think, on under item 5, that clearly liability requires reversal requires legal attention, and the approach that the government tentatively suggested in that report was that, well, whoever holds the unit should hold liability for reversal. That is a question that L1 is the question of liability for a reversal. So that raises the question of who is the liable actor. Is it the project operator? Is it the purchaser? Is it somebody else? Can we afford differential treatment in the cases of catastrophic versus due diligence reversals? Is there a case for risk transfer after an appropriate minimum period, and so on? So the way in which this has been addressed in this paper, is that to think about what's the to what extent do we want to avoid reinventing the wheels? I think we all agree that reinventing wheels is a futile activity, and increasingly in removals we see that there are quite solid experiences from cognate activities that we can draw upon usefully, which are well known to regulators, to market actors, and to positive lawyers. And so we go through that process in that field. I should say Justin goes through that process in this paper. So looking at pre-Kyoto Protocol approaches, the way that the voluntary carbon market approaches such questions, why liability should remain with the project developer as opposed to the holder of the instrument at the removal unit at any given time, and consider what an institutional structure building on liability might look like to create an optimum outcome. So that's the work that this paper is doing. So please do take a look at it on SSRN. It's open access, of course, as I think actually are all the papers that we refer to today. It also links very closely to what Justin will be talking about in a moment in part. But there's also, this is LN, so there's also a wide variety of other forms of liability which need to be taken account of, especially if we think about the best understood or the best regulated form of sequestration that we have, certainly permanent sequestration, which would be CCS. So we have decommissioning liabilities in the oil and gas sector, what role financial securities can play, how leakage and liability can be the cause of standard environmental damage to third parties, and how we account for that, licensing regimes, in particular in the offshore regime. So there's a wide variety of other forms of liability that need to be accounted for. So liability, even if you take a relatively well understood technology such as CCS, quickly expands into a wide variety of other areas, including the public international law areas, which were raised by the London Protocol, but that's not the subject of today's conference. So I will now hand over once again to Sania.
Thanks so much for that. So what our project kind of clearly makes obvious, and not only our project, but I think generally the policy documents that are out there, is that GGRs are our legal reality. And we see this in many different shapes and forms. So for example, the UK Net Zero Strategy, which is labeled Build Back Better, and that was published in 2021, does include GGRs as one of the technologies through which to reach net zero by 2050, which is a legal requirement. So it does outline the certain sectors and industries, aviation and agriculture, for example, they won't be able to reach climate neutrality by 2050, and their technologies will be central. We also have, if we're just giving you a couple of other examples from European context, we also have in Sweden, the Climate Committee published a report also this year, 2022. This is the report in the middle, which clearly it advises the government, in fact, to engage and include and enhance greenhouse GGR technologies in order to reach also their climate neutral targets. And again, in the final one, Luca may come back to that, we have a recent communication from the Commission, the European Commission, which again sets out a pathway for GGRs in Europe. So clearly we have, the landscape is obvious here. GGRs are part of the legal architecture. And then if we go to the next slide, and this is the final slide, there is obviously a huge role done for law and legal scholarship to engage with these technologies. So when we set up, or when we applied for the hub, which is now the hub, law, or us, the legal expertise, which is here today, it was kind of neatly niched into one of the working groups. So you'll see there on your right-hand side, you'll have 6 working packages, and we were in policy and governance. But if you look through, all of those working packages, you'll see the law will be part of all of it. Having a clear strategic vision for GGRs, drafting policy work, that is also part of what lawyers do, creating socially robust GGR development, engaging with stakeholders and publics. This is very much the procedural aspect of environmental law. Lower technology costs, but that is also a role for law in how we create markets. If we engage with subsidies or procurement, these are all different ways the law can engage and to further these technologies. Policies and governance, that is perhaps obvious, but similarly monitoring, reporting, verification, the different standards we set out, how we set out those, what we include, what we exclude. This is all part of the legal craft, which is legal scholarship. And something which is a clear categorization of legal scholarship on GGRs to date is what we have found. It's very much seen as instrumental, but our work, and I hope also our presentations today, will show that law is really not instrumental, but it's very much a creating force, and one that leaves many questions open. So the way we craft laws around GGRs is the way we then decide the future for these technologies. What we also see is that it's not just about public law, it's also public and private expertise really needed here, both in investigating the different controlling regimes that exist, but also thinking about how we can create and draft and develop laws in order to support GGRs that are such a clear and obvious part of the current and future legal landscape of climate law. Thank you so much.
Okay, thank you both. So now let's go straight to the presentation from Justin, please.
Thanks, Anna. I might just share my screen with you. Is that... Oh. Sorry. Can everybody see that?
Yep, we can see that, Justin.
Oh, okay, great. Well, as Navraj mentioned, this short presentation is based on this paper that we recently published earlier this year. And my main purpose today, I think, will be to raise the issues, the questions, some of the questions that Sonia was just talking about, related to fungibility of greenhouse gas removal units. And I won't get into the further aspect, which is the proposal that's put at the end of this paper. I'll leave that for you all to go to the paper and actually read. So it's just a little bit of a teaser there for you. Right. So the Intergovernmental Panel on Climate Change and others have flagged that while continuing reductions in greenhouse gases are essential, these alone are going to be insufficient to avoid dangerous and unpredictable climate impacts. The global carbon budget for meeting the Paris Agreement aspirational goal of stabilising global mean surface temperature increase at 1.5 degrees Celsius by the end of the century has actually been, there have been predictions that this will be exhausted within the next 5 to 10 years. And so after that time, that overshoot will mean that more greenhouse gases need to be drawn down from the atmosphere than are emitted. So in other words, then there will need to be a net negative carbon economy. This means in turn that rapid and significant scaling up of the GGR sector will be required, which could be enhanced by developing a robust market for removal units generated by projects. Building the fact that we're looking at the development of a market here for removal units, I think suggests that building on the experience of carbon markets to date, one of the factors that needs to be explored in the development of this GGR market is the nature of the removal unit that may come to be traded. And in this respect, I think consideration might properly include the legal nature of the unit, the financial nature, and the technical or physical nature of those units. The nature of the removal units will be a function of the particular types of GGR methods which have been applied. And in this respect, the methods display a wide range of characteristics. So really what we need to be able to do is to find ways to value the units generated by these different methods. And I think it's helpful just moving on to looking at the this particular question, how that diversity of characteristics might be accounted for in the development of a GGR market on the one hand, so as not to disregard some of the methods and their characteristics, and on the other, so that the complexities don't impede the effectiveness with which the market as a policy mechanism can develop to promote greater scale in the GGR sector is the challenge that we need to address. So turning to look at just firstly the legal nature, and I will concentrate just on looking at the legal nature and the technical nature in the time we have today, rather than also, I'll skip over the financial nature, which I think is relatively straightforward. But I think it's helpful to review how the question of the legal nature of units traded in emissions markets has been approached to date. This has mainly been in terms of allowances in emission trading systems, as opposed to in the context of project generated credits. And the principal issue here has mainly been whether those allowances constitute property. In the United States, I'm sure many of you will be familiar with the situation whereby allowances as emission permits or administrative permits are specifically excluded, and have been from the outset, specifically excluded from being property to avoid constitutional rights issues in relation to the protection of property from interference without compensation under, I think it's the Fifth Amendment, although I stand to be corrected on that by those of you who are more familiar with US constitutional law. And also, there's no real help in terms of definitions under intergovernmental agreements such as the Kyoto Protocol, or even under the European Union's Emission Trading Scheme directive. In particular, in Europe, it's a matter for national law. So the question of the legal nature of the allowances, and specifically whether they are treated as property, can differ from one European Union jurisdiction to another. Under English common law, however, allowances are more likely to be treated as constituting property. And it's interesting to note that there has been discussion in the academic literature how the legal tests that are applied in the context of allowances in principle could also be extended to credits such as certified emission reductions. And then interestingly, also in my home jurisdictions in Australia and the Australian states, it's interesting to note that there has in the past been legislation which has taken the question slightly further by amending conveyancing legislation to provide legal title to carbon which has been sequestered in the case of forestry projects. And in this context, it's been treated as a what is described, the interest is described as a profit prondera. This operated not as an encumbrance on title, but principally for the purpose of putting third parties on notice of the interest, and it was an interest which would run with the land. So in other words, you may have interests in the offtake in terms of timber or the crops or biomass, but you would also have interest in the offtake from the land in terms of the carbon rights. Just a couple of final observations in this historical context on the legal nature of units traded in emissions trading schemes is that under the Clean Development Mechanism, it's interesting to note that mostly the projects were related to avoidance or reduction as opposed to removals. And similarly, following on from that, in the context of the voluntary carbon market as it stands at the moment, removals are a very, very small part. It's mainly just forestry that they relate to, although with newer projects coming online in relation to sustainability issues and also in terms of biodiversity, there is more in the way of projects based on things such as mangrove regeneration, which have other co-benefits as well. But it is, I think, historically the case that removals have been the poor cousin in relation to these projects, in relation to avoidance and reduction. So just to quickly recap on what I've been saying about the legal nature, I think it's been looking at how the removal units generated by greenhouse gas reduction projects might be characterised. And the context for this is obviously the carbon market, where allowances and credits are traded, and in relation to which the principal issue has been whether or not allowances are properly characterised as property. In the US, such characterisation is specifically excluded, while under English common law, allowances are more likely to be considered property. However, the absence of a clear definition of the legal nature of allowances at the intergovernmental level, at the regional level, and in national schemes has been flagged as being a clear problem that could give rise to legal implications that would impede market development. In relation to credits, there are both parallels and distinctions to be drawn. Project-generated credits are just that. The physical removals are project-generated independently of any scheme by which they may be commoditized or traded. They're not issued by administrative act, but generated as a result of the outcome of the project investment. Rights in and to the credits generated are determined on a contractual basis between the parties engaged in developing and funding the project. More so than allowances under common law, they've got a claim, I would argue, to be characterised as property. And in the case of removal units from GGR projects, this claim would be even stronger, as the removal units represent something more tangible than a reduction or avoidance credit dependent upon a counterfactual argument. The removal unit represents not only the cost of extracting the greenhouse gas from the atmosphere, but also the long-term cost of storing the greenhouse gas. I'll just quickly skip over that, the financial nature, if I could, and if necessary, I can come back to that in the questions. But then to turn to the technical characteristics of removal units. As you're probably all aware, there are various methods for greenhouse gas removals, and they display a range of different characteristics. Some of these characteristics will be common to all the methods, such as costs or timing of removal or the permanence of the storage they bring about. But there are also characteristics that don't translate across all the methods. For example, characteristics pertinent to land-based methods may not be applicable to engineering-based methods such as direct air capture and carbon storage DACs. The question is, what are the minimum parameters necessary for removal units generated by projects based on the different methods to be fungible? That is, to be accepted by the market as interchangeable for settlement purposes. One might look to the common characteristics, but as I mentioned earlier, there's a risk that in doing that, in looking at the common characteristics, a lot of the methods that may be slower or less efficient would simply not be funded and fall away, so that their particular beneficial characteristics, such as ecosystem or biodiversity benefits, may be lost. Fungibility, we have to remember, depends on the context, and the context here is a market created by public policy. The question is therefore, what is desirable or acceptable as a public policy outcome in scaling up greenhouse gas removals? So as a final point here, I might just reiterate that fungibility is not a legal feature of the asset, the removal unit itself. It depends on the context in which it's being assessed. In a market created by public policy, it may be that policymakers can determine that emission trading scheme allowances and project-generated credits based on emissions avoidance or reduction, as well as on carbon removals, are all fungible for the purposes of that market. Nevertheless, I'd argue that emission trading scheme allowances can be considered legally different from project-generated credits, allowances being in the form of an administrative permit while project-generated credits represent far more the outcome of the investment. And in particular, I'd argue that outcomes from greenhouse gas removals projects are different again, since the outcomes represent not only the investment in the project to remove the greenhouse gas removals from the atmosphere, but also the obligation to maintain the storage of those greenhouse gases for a substantial period of time, as alluded to by Navraj, the question of storage liability over time. As such, I think careful consideration needs to be given to the context in which the removal units are proposed to be considered fungible with other units. And this is especially the case where project-based credits are being used to substantiate net zero claims. And I think I'll leave it there for the moment. Thank you.
Thank you, Justin. This was very broad and enlightening, and we will have questions to you after our last presentation. So please, Luca, go ahead with your deep dive on biochar. Let's say we will try to close now in 10 minutes and reserve good half an hour for discussion and the questions lining up in the chat. Thank you.
Great, thank you very much, Anna. Very happy to be here. Within core law, I am dealing mostly with regulation of specific technologies. And when I was looking at the biochar regulation, I encountered a glaring hole in its governance. This is why today I'm going to be discussing the legal hiatus in the CDR governance, particularly on the example of the legal treatment of biochar in England and in the EU. Okay. Just first to start with the jurisdictions, they're both climate action leaders. They both have net zero 2050 targets in law. And despite Brexit, they are remaining quite closely linked. This is by virtue of the retained EU law, which is still part of the UK and English legal order, as well as because of the domestic legislation that is rooted in the EU legislation, particularly in the directives. And if we go to the legal hiatus in relation to biochar governance, I identified 3 different categories of this legal hiatus. The first one is the absence of specific law, then absence of adequate law, and lastly, the absence of legal recognition. And I'm going to talk briefly about each of those and provide some examples for that. So if we start with the absence of specific law, this is probably the most general category, and it emanates from the reactive nature of the legal regime. It means that no specific legal rules exist for the CDR method, and is a consequence of the novelty of the method. In that case, the question arises whether the general legal frameworks are applicable. This has been previously already dealt with within the technology regulation literature. Particularly Roger Brownsworth dealt with that. And the dilemma, as it was presented, was the dilemma of the regulatory connection. And here the problem is that if we decide to apply the general legal frameworks, there might be an issue, a rule of law issue. More particularly, the principle of congruence can be endangered. But if we decide not to, there might be a legal void, which can hurt certain legal values that the law should protect. That's why Brownsworth coined the distinction between productive and unproductive disconnection, which is centered around whether the novelty of the technology can actually fall within the intent of the general legal framework. If it can, then it's an unproductive disconnection. If it can, it's a productive one. And in the case of unproductive, the general legal framework should be applied, whereas in the case of the productive one, he advocates for the discussion about the future regulation of this topic. In the case of biochar, it is hard to follow this methodology because of its complexity. Namely, biochar is an umbrella term which covers so many different materials which are similar, but whose utilization is completely different. Oh, sorry, a bit too fast. Also, the other question here is that it can give rise to conflict of enshrined values, particularly in environmental law, where the main intent is to protect the environment and usually also human health. By the intrinsic purpose of biochar to mitigate climate change, there is a problem that basically we have to decide between long-term and short-term environmental mitigation in some sense, because biochar can pollute and provide, for example, with heavy metals, with PAH pollution. We actually have to decide between this one and a long-term risk mitigation of climate change. And this makes it very difficult to actually apply this methodology to the case of biochar. If we go to a concrete example of diffuse pollution regulation in England and the EU, this is regulated on the English level in the nitrate pollution prevention regulations, which emanates basically from the EU nitrates directive, and it establishes administrative obligations and quantitative limitations regarding the application of nitrogen fertilizer in the nitrogen vulnerable zones. Even though this sounds very specific, it is actually quite a general issue, because 55% of land in England is part of the nitrogen vulnerable zones regime. Nitrogen fertilizer, by the definition from those two regulatory instruments, includes any substance that consists of any amount of nitrogen compounds and is used on land to enhance growth. The other set of regulation is the reduction and prevention of agricultural diffuse pollution regulations. This one is translating the water framework directive from the EU, and it mandates that each application of manufactured fertilizer must be planned in a way that does not exceed the needs of the soil and crops. A disconnection arises in relation to biochar, because biochar at the same time does contain the nitrogen compounds, but also has the possibility to retain those. And even more, biochar can be able to prevent leaching of other nitrogen inputs into the land. And here, if we look at the legislative intent to decrease the agricultural pollution, it is really difficult. As mentioned before, biochar can also cause leaching of other pollutants, such as heavy metals. It is very difficult to actually decide whether it does fall within the intent or not, and we get conflicting results. Also, what has to be noted here is that those two legal acts do apply to the agriculture function, whereas it is very questionable where the CDR function of biochar sits in. So if we come to the second category, this is the absence of adequate law. This category basically means that the specific rules exist and they certainly apply, but are unfit for the job. In this case, this is a very normative category, which is submitted to two main criteria. One is the quantity of application, which has to have a certain contribution to climate change mitigation and reaching net zero by 2050. On the other hand, it also has to have certain quality to it. Particularly, the regulation has to ensure that the scale up is done sustainably. This criteria is particularly important because of the overwhelming corporate interest that exists in this area now. Just to note, both of those criteria are actually in EU as well as in the English law. And if I go to the example of waste management permitting in England in relation to biochar, as you probably all know, biochar has a long history in connection to waste regulation and to waste labeling. And the Environment Agency applied specific regulation to this in the form of low-risk waste position, both for biochar production and biochar application. Basically, what it does with this low-risk waste positions is to to promise that it will not enforce the environmental permit requirement if the biochar activity meets the description and criteria therein. At the same time, also the activity should not and is not likely to cause environmental pollution or harm human health. And if we look at the two criteria, the quantity, there is big problem because with the two low-risk waste positions, because they have big and very strict scale limitations. For example, the application of biochar is only possible up to 1 ton per hectare, which is just not sufficient for the utilization for as a CDR. Also, this legal basis is very weak. It's just basically it promises that no enforcement will happen and is prone to change, which in light of a multi-centurial and irreversible storage of biochar is just not adequate to induce confidence with the businesses that want to apply it. At the same time, it still retains the waste obligations, certain waste obligations, such as, for example, duty of care, which can also be problematic. When it comes to quality of the application, the problem is that the regulation from the Environment Agency does not do any prior checkup. It entirely relies on this criteria, which was mentioned here, that it will not cause environmental pollution or harm human health. And at the same time, it incentivizes utilization of non-waste materials, in case of which this whole criteria would be evaded. Looking from a more life cycle perspective, this is obviously not that good because it encourages specifically designated biomass production, which has its own predicaments. If we come to the last category, this is the absence of legal recognition. This is in a sense the most fundamental category of them all. And it basically means that the CDRs, or more accurately steps leading to it, are not a specific category that abstract and general law would recognize as an object of legal relationships. Basically means that in a sense, when a producer makes biochar and then applies it to the ground in order to remove carbon, there is no legal effect given to it per se. Because here again, there is absence of law. The general rules which would apply would be enabling rules in the sense of HLA Hart, more particularly contract law, and the CDR would basically be what the contract parties would determine. But here the question arises whether the values centered around contract freedom are the right ones to govern a credence good such as CDR. It might hold true that other values are more important, such as, for example, confidence building and environmental protection or ensuring removal permanence. Just to illustrate this quickly with the EU and English regulations. In the case of EU's land use change and forestry regulation, there is actually given a forum to the legal recognition of biochar and its CDR function by referring to the IPCC guidelines. However, and actually the IPCC guidelines 2019 refinement does give some recognition of a CDR purpose to biochar in the form of soil organic carbon enhancement and as a charcoal as a harvested wood product. However, the refinement is not enshrined in EU law, so it does not make any difference. Then we also have the novel Energy Security Bill, which has been put into the legislative procedure this summer. It aims to define removals broader than just LULUCF as it is made now, for the needs of the carbon budget. But here again, for the accounting purposes, it still refers to the IPCC 2006 guidelines, so no help there. And finally, if we look at the influence this legal hiatus has on biochar and its scaling up, the most obvious is in the legal uncertainty that it causes. There is huge uncertainty about the existing regulatory position of businesses, which is harmful to them, obviously, harmful to them as well as to the investors that would like to make a business case out of this and apply it on a larger scale. At the same time, it is problematic for the environment because it does not make clear what can and what should not be done. The second effect it has is the risk mismanagement of the question. Novel methods and technologies are always permeated with risks. Contrary to the popular belief, there are not only risks of application, but also risks of not doing so. In case of biochar, the risks of application are pollution, in some cases also albedo decrease and fire hazard. However, of not doing so, there is just no contribution of biochar to climate change mitigation or to improving agricultural resilience by improving nutrient efficiency use. This is problematic because general legal rules do not consider the specific risk equation, and it does not minimize the risks, and it does not capitalize the benefits of the technology. Lastly, there is a problem of public non-acceptance because of it. As Sanja mentioned, law is not just an instrument, but it also informs the views of the public. In a sense, if there are dangers of leaving it to general legal categories when they do not depict the technology well enough. And this is especially problematic with biochar because it is commonly labeled as waste. And maybe the approach that the EU has taken in the last year as presenting biochar as a fertilizer would be a better approach. However, actually, it was already shown on the basis of the enhanced rock weathering that it might even be better for the public acceptance to portray it as a fertilizer than a CDR. Thank you very much for your attention and looking forward to your questions.
Okay, thank you, Lucas. So since you are, well, the last presenter, maybe I will hit you with the question that we got already early on, just to solve this puzzle of gases related to production of biochar. And basically the question is that the carbon yield of biochar is maximally 50%. So the other 50% is gas, pyrolysis liquid, potentially toxins and other hydrocarbons. And how do you see these off gases becoming regulated? And also the question is also relevant for small-scale producers and farmers. But then when we look at it as, okay, a CDR webinar, like what then would be the implication for the removal value with leaving this other part of the equation unregulated, I think.
I mean,
your thoughts?
If I tackle the first part, in the EU as well as in the UK, this is already regulated generally by environmental permitting. Basically, when a pyrolysis plant wanted to start operation, then it would have to get the environmental permits to do so. This is also then with the waste status of biochar, it's also demanded to get a permit for that. There is some problematic still here because it's uncertain under which category of the installations this would actually fall under. But as much as I've been talking to people dealing with that, that's more of a technical issue. It's not such a big problem when it comes to the to actual regulation and the general and abstract law. As it relates to the other, to the second question about small-scale applications, I think it will really depend on the purpose of application, and I think in this case it will have to the regulators will have to kind of make a distinction between the agricultural use and the CDR use. And whether or when this will happen is not clear, but I think with the upcoming certification in the EU, especially of carbon removals, this might be a step forward in doing that.
Yes, definitely. We're looking forward to the CRCM framework solving many of these issues. But well, then mostly related to accounting for actual, carbon accounting for removal rather than solving all the other environmental issues around each and every technology. And then the second question from the same participant is, it's a statement that biochar has an advantage of accepted permanence. This to me sounds that, okay, it's a bit of an overstatement, like there's a continuum, it depends on the application. And okay, soil, then it disintegrates. If you apply it in building materials, it's quasi-permanent. But the question is more about this extra value of permanence in fertilizer, water retention, improvement on crop yield. The question is the real benefit to crop yield? Perhaps how to calculate it, and is it enough to justify biochar as a soil amendment for large-scale farming? So again, we are going a little bit away from carbon removal for the purpose of, reducing atmospheric CO2 and into all co-benefits agenda. So Navraj?
Yeah, thank you. I'll pass over to Luca in a moment because he's the expert. But a couple of things, I think, broader points to make here. One is that the question of permanence of biochar is highly contested within scientific research. The mean figure is somewhere around 100 years. 100 years is nothing close to permanent. Some figures are a little bit shorter. There's an emerging literature which is putting the figure at about 1,000 years, which is still not close to permanence, certainly when compared with geological storage. So there's a wide range of scientific, valid scientific opinion. Reasonable people can disagree about where the science is. And that's very much what the focus of our demonstrator project is. There are people who are doing this fundamental scientific work, and there are people around the world who are doing engaged in parallel efforts. But it does go to a broader question, which is present, and Justin referred to this in his paper. It goes to a broader question in the paper about what the parameters are for how you value any given removal unit, and permanence is very much one of those. And if the gold standard for permanence, let's say, is certainly within this context of human existence, geological storage and geological storage for formations, which then mineralizes, and we can anticipate or model that it will be there for millions of years. That's something which is close to meaningful permanence, certainly for the purposes of human life. But how you actually model that in a legal removal unit and how you value that in a legal removal system is TBC. We've got proposals on how you might do that, but it's a long way from a proposal to a global legal standard. Luca, I'll pass over to you.
No, I think you actually did a very well all-encompassing answer. It's just about the yields. If I'm completely honest, I'm not sure about it. I'm just a lawyer. But I do think there is a big scope for biochar to be, at least in some sense, of an agricultural use and of improving the nutrient efficiency, particularly, and water retention and all the properties that it holds now. And obviously, this is still disputed, as it is this dispute about how long it can actually endure in soil. And that's why some people are actually arguing for storing it in concrete. This is all to be seen. We are really just the beginning of this exploration. And yeah, hopefully the discussion goes onwards.
Mm-hmm, mm-hmm. Yes, this is very relevant, and for the European framework, the CRCM, which will have a primary focus on carbon farming, and the European Commission is really looking at developing certification for different carbon farming methods, including application of biochar. This is relevant where these applications will be placed, but also that for us, this when we talk about fungibility between our members and the creating of the market for removals, we are looking more at the fungibility of a removal credit with an emission allowance, like on a higher level, rather than already jumping into fungibility of different methods. Because what we see as an indication in the EU framework is a long-term vision, long-term plan to actually include certain removals in the EU ETS, fungible with allowances. So these questions will need to be solved. And then with the CRCM, the impression, I mean, the proposal is still not yet on the table, but the impression is that the Commission wants to go slow and is not looking in the very first phase at tradability. So then there is no need to make them fungible from the start. But for example, carbon farming could be an sort of in-setting exercise for corporates to cooperate closely with farmers and then source these credits. Well, like agri-food companies could sponsor certain carbon farming practices for farmers and then compensate within the value chain. Which seems okay from like legal perspective and regulatory, and it only becomes I would say dangerous if we're looking at then using this carbon farming credits, including, I don't know, biochar or completely non-permanent removals as an offset for fossil emissions within the EU ETS. So this is like much, then picture becomes much more complicated. But for us, someone here in the chat is proposing a question of the alternative is non-fungible GGR. So each GGR will stay in its own box and will be used for, well, offsetting for different purposes. What do you think? Maybe all of you or other speakers. Justin.
Yeah, thanks, Anna. I might jump in there just with an observation that I think from my perspective, if there were to be a market in removal units, which seems to be the policy mechanism of choice in most cases for trying to stimulate investment and drive up the scale of the sector, it would be appropriate for it not to be connected with the emission trading scheme. And I think that's because there are fungibility questions between the units, but also in particular, the emissions trading scheme is on a particular trajectory, or at least in theory, should be on a particular trajectory to gradually reduce the number of allowances being issued, simply because that's the purpose of the scheme, ultimately. And so that's going to greatly reduce the liquidity of in that market eventually over time, or one would expect that. And so there would be much greater recourse to the removals units if the markets were combined, and consequently that may have consequences for the actual removal or the continued reduction in emissions per se. I'm saying this as a lawyer. I'm going to go to Luca's disclaimer, which is that I'm a lawyer, not an economist. But that's one aspect. The second aspect is, of course, that as I pointed out at the start of my presentation, the global carbon budget for emissions, continuing emissions, is being exhausted very rapidly. At the current rate of emissions, it's being exhausted very rapidly. And therefore, the scale of removals needs to be massively accelerated. And I think this is the argument that the IPCC has been putting forward for a while, more strongly with successive publications. And so the question is, how can you have an emissions trading scheme when you really don't want to have any emissions at all? Really what you want is a market based on removals. And since the removals and the emissions trading both address, or the emissions trading allowances both address the same emissions, it would be sensible over time for the emissions trading scheme to be gradually phased out and replaced with a market for removals.
Mm-hmm. I think that's the long-term plan, actually, that the number of allowances goes to zero in around 45, and then we are just trading removals. Yes, Navraj?
Actually, Sanya already had my hand up, so I'll defer to her first.
Sorry. Yeah, no, it's no, this is a discussion that we can have for a long time. And I think this is one of the discussions that we are having in the legal community. I mean, I think, so Navraj mentioned at the start of our presentation that there is a lot of skepticism in the climate law community towards removals. And one way to address that skepticism could be to have two separate trading schemes, right? So that you kind of keep the two separate for those reasons, right? So that could be kind of one rationale for having two separate ones. The point that Justin mentioned, that the fact that hopefully we'll reach the legal obligation on net zero by 2050, then having those two becomes a bit well, you kind of need to either, you would kind of have one then, or merge the two. But the point is, I'm wondering, I mean, we can already see in the net zero strategy, there is already an awareness that some sectors will be difficult to run as net zero. So perhaps there's also an understanding that there will be some sectors which will continue to emit and pollute also after 2050. So that again could be a reason why you would want to have two separate trading schemes. So the point of all this, I'm not giving a very clear answer, but I think it goes to one of the arguments that Navraj and I were trying to make in our presentation, that there are many questions here. There are many legal constructions for how we regulate and approach GGRs, and it will depend on a lot of different perspectives. How do we identify the core problem here? And the way we define that will also, I think, define how we ultimately decide to respond to GGRs. I hope that makes sense. Navraj, over to you.
The only thing I would add, really, and this is part of much more of a broad response, is that, you know, we're very quickly and going to get to a position whereby every emission is beyond the cap, beyond the global carbon budget, right? Where every emission is causing harm beyond the 1.5 degree threshold. Now, whether that's 5 years, probably not, 7 years, possibly, 15 years, almost certainly, you know, we're very quickly going to be at the position whereby there's a strong moral and arguably political and arguably legal case for there to be a structure whereby every emission is attached to every emission is attached an equal and opposite legal obligation to remove and store. Right, that's essentially the carbon take-back obligation. So, you know, this is a combination of on the one hand, the paper in Nature, the recent paper in Nature by Johannes Bedner and others, and the approach of the carbon take-back obligation, which Miles Allen and Stuart Hazeldine have been pushing for a number of years. So, you know, I think it's Philip has put in the chat, emit one, remove two. Well, you know, you could say if you're in the United States, it's emit one, remove seven, and if you're in Chad, it's emit one, you know, remove 0.0001. You know, however you're going to do it, but the principle of an obligation to remove and sequestrate is a future horizon, but not terribly far away, and it will have to be addressed.
Mm-hmm, mm-hmm, absolutely. Yes, I just want to reflect on what Sanya said. Yes, absolutely. We I mean, as a emerging industry, we advocate for a separate, ambitious, binding target for removals, technological removals, because the land-based are already somewhat regulated. And then looking at EU scenarios, we would need around 300 up to 300 million tons a year by 2050 of these technological removals. What we now have on the table from the Commission, the communication that you presented on the slide, is aspirational objective of 5 million tons by 2030, which is like nowhere near the ambition that we need. And our members say that they can do 200 million tons by 2030. Sweden alone has a bigger target than that nationally. DAX are building facilities for 4 million tons by 2030. So we see like a big gap between the legal ambition and actually the industry growth here. So absolutely, we are behind the separation of targets, polluter pays principle enacted through CTBO. These are all very, very relevant, like actual pragmatic policy asks for our organization and our members. So I find this like a connection between your work and our advocacy very, very relevant.
Yeah, I mean, just to follow up from that, I mean, if we talk about the EU context, the member states also look very differently, both in terms of capacity and in terms of their own technology push. I mean, for example, if we look at Sweden, you know, there is also, you know, there is a lot of forestry, and that is very much where they see the technology going. But that is not necessarily where you would have in other member states. So you do also see different interests, perhaps, or different pushes in the European Union in that regard. Yeah. Thanks.
For us, the starting point for the European Union is the revision of what we call national energy and climate plans, which sort of overlap with the NDC's scope, and then to install an obligation for each and every member state to well, indicate at least the ambition in terms of technological CDR, also the capacity, geological storage capacity, technological capacity, and then also reflect this with the estimated amount of residuals in domestic context, and then to see if the two match. On that basis, we could then discuss adequate targets for the EU. But this is still a question, well, for 2030, I guess, here. Okay. I see one, we still have 1 minute, legal framework surrounding paying for and removing legacy emissions. We didn't touch upon the historical emissions, but maybe someone quickly can respond to that.
I put something in the chat very briefly. I mean, this is essentially the loss and damage debate. That's out with what we're talking about today. It's likely to be much debated in COP this year. Personally, my view is that whilst it's probably the right thing to do, it's unlikely to come to pass in that particular forum, or indeed any.
Yeah, we had the announcement from Denmark. I don't know, but I think it's the rather exception, will remain exception rather than rule in that sense.
To give you a sense of where the debate is, Scotland has committed to a loss and damage fund. So far, it's got it's either £1 or £2 million in it. So this is the scale of ambition. I mean, that might pay for somebody's birthday party, but not a great deal more.
Okay, so let's end on this on this note, and thank you so much for this wonderful discussion. And well, we can always continue offline. That would be great. And I let Will wrap up with his remarks as well. Thank you from my side.
All right, thank you so much, Anna, and thank you to all the panelists. Obviously, these some of these issues are sui generis, right, based on the EU and the UK's respective regulatory frameworks. But there's a lot of themes, right, that are important and relevant everywhere, right? Including issues of equity and justice associated with, proposed carbon takeback proposals, as well as loss and damage issues, integration within NDCs and equivalent national obligations. And so it's very interesting to see what's happening in Europe. Some of the states are clearly laboratories on a lot of these issues. And so I really appreciate your insights. Thank you very much.